I'm James Reeves. I'm probably not your lawyer. This is not legal advice. As many of you know, I'm the U.S. Law Shield Independent Program Attorney for Louisiana and Mississippi. If you want legal representation for personal defense situations, whatever, you use the code when you sign up, NGGC, over at U.S. Law Shield. You'll get a few months free. My Range, Neutral Ground Gun Company in ARB, Louisiana will get like $20 or something. So think about it if you're not already covered by a legit program. Not all of them are. One of the services Law Shield offers is the ability to get like a free advisory legal opinion from your program attorney in your state if you've got legal questions, and holy shit, I get a lot of them. But there's one that I received this week that made me think about making this video. The question, verbatim, is, can I shoot a trespasser on my property or point a gun at them to show them I mean business if they refuse to leave? I mean business. If I had to answer that question using symbolic logic for my other fellow symbolic logic virgins out there, the answer would be no. Just because someone is a trespasser doesn't mean you can shoot them or point a gun at them. This is more of a Venn diagram situation. Trespassers and people you can legally shoot, they overlap a bit, but they're not the same circle. I'll explain the law in general terms, but fortunately we've got a great illustrative, high-profile, real-world example that just happened to look at here. You guys saw this on Twitter, you saw it on X, whatever. The case of John Riley. No, not the guy from Step Brothers. That would be hilarious because you guys have seen this video on Instagram, social media. This happened in New York just a few weeks ago. Riley, 48-year-old boomer, and I say 48-year-old boomer because using a .45 ACP to shoot at someone turning around in your driveway is right up there with size 28 font on your iPhone or making noises involuntarily when you get up off a couch. One night, DoorDash driver gets lost. I feel bad for this son of a bitch. His phone's dead. He walks up to Riley's house, not knowing he's a psycho. He's got a bag of food, rings the doorbell, says, "Hey man, did you place this order?" Riley tells the guy to leave. Guess what the driver does? You'll never guess. He's like, "Okay, I will leave." He gets in his car, drives off. While he makes the risky decision to leave, i.e. doing what he's asked, Riley comes out of the house with a .45, launches a .45 ACP round into the ground, which likely created a minor seismic event, and then takes an offhand shot at the car, which bizarrely enough hits the driver. I wonder if John was like, "Yep, got his ass," or if he was thinking like, "Oh shit, I was not expecting that to happen." So the driver goes to the ER, has emergency surgery, 2 feet of his small intestine removed. Huge win for .45 AARP shooters, not so great for Riley. Police execute a search warrant and charge Riley with not just the shooting, but during a search they find 7 pistols in the house that Riley did not have permits for. New York, right? So in this act of remarkable dumbassery, he also exposes himself to more criminal liability. He's now facing charges, including attempted murder, first-degree assault, criminal possession of a weapon. His bond set at $500,000. So win, lose, or draw in the lawsuit, he likely had to pay a bail bondsman $50,000 to get out of jail, which is money he will never see again. A lot of you guys don't think about that. Even if you beat the charges, if you pay a bail bondsman, you give him 10%, you get piped for 5 figures. If you get booked on a gun charge, you'll never get that money back. There's nothing you can do about it unless you just want to stay in jail until trial. So make sure you get bond coverage. This case is pending. I'll do my next video shirtless if this guy isn't convicted of a felony or doesn't go to prison as part of a plea deal. So why am I so confident about that? Because we have not one, but 2 just as dumb recent trespass cases that made national headlines. First, Ralph Yarl. 16-year-old kid rang the wrong doorbell in Kansas City trying to pick up his younger brothers. Andrew Lester, an 84-year-old homeowner, shot him in the head with a .32 through his glass front door. Miraculously, Ralph survived. Lester charged with assault, armed criminal action or something like that. I don't really know Missouri laws. Anyways, he ultimately pled guilty in 2024. He was sentenced to 7 years in prison, but ultimately he did beat the system by dying a couple of days after the plea deal, meaning he never went to prison. Talk about sticking it to the man. Second, Kaylin Gillis, 2023. This one's really sad. 20-year-old woman riding in a car with friends looking for a house party. They accidentally pull into the wrong driveway in rural New York. Kevin Monahan, 66 years old, comes out of his porch with a 20 gauge shotgun, pussy, and fires 2 shots at the vehicle. 1 round hits Gillis, kills her. Monahan claims first he felt threatened because there was a car, and I think it was like 2 motorcycles or something, in his driveway. At trial, he kind of changes his story a little bit. He says he tripped on a nail. He was convicted of second-degree murder, sentenced to 25 years to life, where his butt's going to be tripping over some nails, if you know what I'm saying. The judge absolutely popped off on this dude at sentencing. The transcript, worth a read if you get a chance. So the answer is no, you can't shoot someone for being a trespasser. But remember, most states have 2 types of trespass. You've got civil and criminal. Civil trespass, someone enters your property without permission, but without malicious intent, sometimes without even realizing it, that they're on private land, whatever. Think about a Girl Scout selling Girl Scout cookies. Technically, she's trespassing, but not criminally. In fact, the legally permissible act of approaching a door, knocking on it, waiting for a response, and leaving is actually known as the Girl Scout rule. Comes from a Supreme Court case, Florida versus Jardines. Pull a gun in this situation, you have probably committed a felony. But next level, criminal trespass. This involves someone intentionally entering or remaining on your property without authorization, often after receiving actual or constructive notice to leave. It's 2 a.m. Someone climbs over your locked backyard fence, starts trying to open your back door. That's almost guaranteed criminal trespass and potentially attempted burglary. In many states, including Louisiana and Mississippi, displaying or using a firearm in that scenario, that would absolutely be justified under self-defense or Castle Doctrine laws. And in Louisiana, even if you shoot the guy through the door, you'd be legally above board, although not advisable in most cases. Related to that, you guys have been waiting for me to say Castle Doctrine, right? First, if you're defending any of these people, the 3 shooters I've mentioned in this video, because of the Castle Doctrine, dude, travel more. Fall in love with a woman. Buy the Jerry Maguire original soundtrack CD. Join a bowling team. Some shit like that. You need a human experience, or at least a solid self-help book. I don't know. The Castle Doctrine isn't a license to kill. It's a presumption in most cases. 24 states do not require a homeowner to reasonably believe that they're being threatened when they use deadly force in defense of a habitation. Many states allow the finder of fact to presume that the homeowner, if there's someone in your house, automatically reasonable fear. Just no matter what, someone's in your house, you're reasonably in fear for your life, so you've already satisfied that. Number 1, though, we're talking about inside the home. Right? Trespassers inside the home, inside your structure. Now, the area outside your structure, like your yard, whatever, curtilage. According to my research, only 9 states expressly include the curtilage in the Castle Doctrine, like your yard or whatever. Number 2, even the most lax states with Castle Doctrine still require a reasonable belief that the amount of force you used is necessary to require the intruder to leave. Remember, I always say, rule of thumb for self-defense, reasonable fear, reasonable response. The Castle Doctrine typically, in most states, resolves the first one. It says, okay, someone's in your house, someone's in your yard even, and that could give you reasonable fear. We've satisfied that. But you still have to satisfy number 2, reasonable response. So what about shooting trespassers, showing them your gun? Only a small minority of states extend the Castle Doctrine to the curtilage of the property, and even then, there's still a requirement that your use of force be reasonable, whether that's flashing a weapon or using it. Don't go and show the girl trying to sell you Thin Mints your piece. I'm not your lawyer. This is not legal advice. Thanks for watching. Be safe. Please don't shoot someone just because they're turning around in your driveway. All right?